All right, folks, it's time for our favorite podcast, Cut to the Chase, and that is what we're going to do right now. I'm bringing on Matt Hosen from the law firm of Quinn Emanuel to talk more 3M litigation. Matt, how are you doing today?
Good. How are you, Greg?
I'm excellent. Thank you for asking. Fun, enjoyable weekend, the Passover, and the Passover festivities for me are going to start very soon. And our Last Supper, I thought there was only supposed to be 12, but we got 30 people coming on. So,
Oh, wow.
Hopefully you got something going on good too yourself.
Well, I'm in Gainesville. Actually, we have the next 3M trial that's about to start here on Monday. So I will be working all weekend.
All right. So Matt has been involved in all the 14 trials. I know all my listeners here have listened to all my programs and have listened to Mike Burns come on giving updates. But we're going to talk a little bit more 3M. Matt, in addition to having been involved in all 14 of the trials and is like a 3M expert mass tort guy, Matt also brings a little bit of extra flavor. He's specialized in antitrust litigation, complex commercial litigation throughout his career as well. And so today's topic is going to be the connection between, or not the connection, but how baseball and 3M, what they share in common. So Matt is going to explain that to us. So you ready to roll, Matt?
Sure.
All right. First of all, one of the things, I've done like 6 or 7 episodes on the 3M, and I don't think I've really clearly explained to the audience what the problem is with the earplugs. So why don't you explain what happened to these earplugs and what the lawsuit, the theory of the case is all about?
Sure. I actually have a pair of the earplugs here with me, so I can kind of show you.
Excellent. Excellent.
So this is the earplug at issue. It's the Combat Arms dual-ended earplug, version 2. This green end acts like a regular earplug that everyone knows. You put it in your ear, it blocks out the same amount of sound regardless of how loud that sound is or what source it's coming from. The yellow end of the plug is kind of what makes this plug special. It's called the selective attenuation end, or the nonlinear end. And how it works is, it's hard to see here, but there's a little hole in the center here of this earplug, and it's a plastic stem that kind of connects both ends of the plug. And at the end of this stem on the yellow side, there's a little kind of canister filter with a little hole through it. And what that does is that how it's supposed to work is you put the yellow end in your ear and you're still able to hear ambient low-level sounds around you pretty clearly. So like if someone's speaking next to you, or a twig breaks next to you, you should still be able to hear that theoretically. But if there's a loud impulse noise like a gunshot or an explosion, the filter is supposed to block that harmful sound and protect your hearing. That, in theory, is how it's supposed to work. In terms of what we are alleging is defective about this plug, it's a couple things. A lot of it has to do with this stem, this white stem in the middle. And I'm going to take off one end of this just so you see it. So you see this stem here. This is a very hard plastic. It's called Delrin plastic, and you can't bend it. And then if you can also kind of see, it's a little darker here at the end, and that's the filter that's contained inside the stem. And so the problem that we're alleging is that this stem goes pretty deep into the largest flange on that end. It goes up until just about the front of that flange right there. So this piece of the stem is actually going inside your ear canal when you wear this plug. And that's a problem because the ear canal, everyone has a different ear canal, but pretty much all ear canals are pretty curvy. And this, of course, is a very straight, hard stem. So what happens is once it gets in the ear, the ear canal basically wants to push it out. And so, in general, there are many, pieces of literature out there, including from the EPA, where they're giving guidance to earplug manufacturers, and they're saying, obviously you don't, the ear canal is twisty and curvy, and so you want to put soft, pliable, flexible materials in there because otherwise it's going to come out. So that's one of the key problems with this stem. We allege that it's too stiff and too fat, meaning it's too wide at the end, the part that goes in the ear. Now, one of the other key defects that we're alleging is that, you see here, it's a dual-ended plug with two flanged ends. So when you put one end into your ear, most people have this thing called a tragus that's right here. And what happens is, if you can get this earplug in far enough, the other end of the plug, the other end of the earplug, it's going to press against this tragus. And that causes this end, the non-inserted end, to kind of deform, right? And when it does that, that deformed end wants to get back into its original position, because that's what plastic does. And so it's going, not plastic, but rubber. And so that, again, that's another thing that's going to be pulling this thing out of the ear after you insert it. So those are kind of the key defects that we're alleging. Now, there's also another key claim in the case are these failure to warn claims. And, these involve the testing that 3M and its predecessor Aero Technologies did on this plug, some of which we, allege was not disclosed to the military. Basically, any risks about this plug that 3M knew that they didn't disclose to the military, those would kind of be encompassed in that claim. And, a lot of that covers the initial testing of the plug, some of which was shared with the military, some of which wasn't. But then it goes later on, because you have people from the military reaching out to 3M and Aero asking for information about this plug, and then Aero kind of deciding what information they're going to share and what they aren't.
So did the military, all right, how long was this earplug in use?
So it was first sold to the military in 1999, and it continued to be sold until 2015, when it was pulled from the market.
And during those 15 years, I mean, I'm trying to figure out how obvious this defect is. It sounds like it's just not, fitting in the ear properly. How did they not realize from day one that there was an issue, the higher ups?
I'm glad you're not on our jury, Greg. So here's the thing. Here's the thing with this earplug. It is a very unique earplug. There has never been a dual-ended flanged earplug like this, and there hasn't been since. And there's a reason for that, and it's because of this tragus issue. Now, it's funny because they're actually, the whole issue of, oh, well, isn't it obvious? Wouldn't it have been obvious? Well, actually, the answer is no, because actually 3M tested this plug in their own laboratory with their own test subjects, some of whom were employees. And this plug, they thought, the people in 3M testing this plug thought that the test subjects were getting a good fit with this plug, that it was well seated in their ear, that it had an acoustical seal. But in fact, they ran the test and they found out, oh, actually, this plug is letting too much sound in. It's not providing much protection. So they couldn't tell from a visual from a visual inspection if this plug was actually well seated and had an acoustic seal in the ear, even for a very short laboratory test in a very sterile environment where you have the experimenter jamming the plug in the subject's ear. The subject is sitting perfectly still, and they're only wearing the plug for a couple minutes. And yet, even in that environment, this plug was loosening and not providing protection. So, you know, you would think it would be obvious, but it really isn't. And a lot of it has to do with the unique design of this plug.
All right, so most mass tort, this is the largest mass tort case, I believe, in the history of mass torts. 3M, over 280,000 plaintiffs, veterans are involved in this case. Most mass tort cases start, no, I wouldn't say most, but a lot start when there's a problem with the product or the device or the drug, and then the FDA pulls it from the market. There's a recall. So we all know, everybody, like the lawyers know, the world knows, the doctors know, and it's pretty, you know, you don't have to be a rocket scientist to know that there's something awry here. But the 3M litigation did not evolve in the same way. So how did this, I mean, there was no like product recall. I mean, I know they took it off the shelves, but how did the litigation sort of unfold?
All right, this is gonna be a long story. All right, it starts in 2013, okay? 3M sues their competitor, Moldex Metric, and Moldex was starting to sell their own competing earplug to this, but it was single-sided, but it had the nonlinear technology included in that. And so they started, Moldex started selling their plug to the military, and the military started making large orders of that plug. Well, 3M had a good market position at that point. They had pretty much control over that nonlinear earplug market. So they were trying to come up with ways, you know, to basically stop Moldex from selling this product to the military. And, you know, one of those ways was, well, let's bring a patent infringement suit against them, alleging that they violate a patent. So the patent was for the dual-ended design of the combat arms earplug. There's a, they hold a, well, 3M doesn't hold the patent. A third party called ISL held it, but it's licensed by 3M. The patent is licensed. And so they asserted, 3M asserted that dual-ended patent against Moldex's single-ended earplug. Doesn't, look, I'm not like a huge patent lawyer, but like, this is one of my first cases I worked on as a lawyer. But I got it. I mean, it was just obvious from the patent that a dual-ended patent could not read on a single-ended earplug. And so I wasn't involved in that 2013 case. A partner I worked with was, but that case ended up going on for like a year and a half. And eventually, after summary judgment had been briefed and right before the hearing, 3M decided to drop its claims. And so at that time, the partner I was working with, Hal Barza, you know, he was actually telling 3M this the whole time, their attorneys, like, this is a frivolous patent infringement claim. We're going to come after you on this. And in 2014, in fact, this is where I got involved. I had just become a lawyer at this point. And at that point, Moldex then turned around and sued 3M. And we alleged an antitrust sham litigation claim, which basically says that we basically had to prove that when 3M initially brought the lawsuit in 2013, it was objectively baseless and subjectively baseless, meaning that it's objectively baseless in that no reasonable litigant could have thought they would be successful on the merits of the claim, and subjectively baseless in that they did it with an improper purpose. They did it with an anti-competitive, like predatory purpose. And so in that case, and then also we alleged in that case, we brought an unfair competition claim under California law. And that ended up being very important because that allowed us to get discovery about this earplug. And it was it was in the course of getting that discovery that I found the Flange Report, which is kind of the smoking gun document where the people who developed and tested this plug internally at 3M actually wrote up a report about their findings and what they observed in that testing. And part of their observations, and in their observations, they describe some of the defects that I just talked about a few minutes ago, where the opposing edge would press against the tragus and tend to pull out the earplug over time. So it was a pretty big document, and it's we used it at a lot of depositions in that case. Eventually that case settled. And then, but while that case was going on, we filed a qui tam case on behalf of Moldex against 3M. And we were bringing that on behalf of the US government because the government had purchased millions of pairs of these earplugs for the soldiers over that 15-year period. And so the qui tam, that case went on. It was a whistleblower lawsuit. That case went on for a couple years, and eventually that case settled. And 3M had to pay. 3M settled with the U.S. government, who intervened in the case, and they paid $9.1 million. And then that was made public. There was a press release about that. And that is what spawned kind of all these plaintiff lawyers around the country who started to sign up, veterans and active service members who had used this plug and who, as a consequence, have hearing loss and tinnitus.
All right. So Moldex is 3M's competitor. They are involved in antitrust litigation. You, Matt Hosen,
Yes,
gets that Flange Report. You're the first one. You're like, whoa, I can't believe this is happening. My life will never be the same.
No. I did not think about that at all at that time. I was just kind of like, I was pretty much the only one reviewing documents on that case, because honestly, it was a pretty small case. There wasn't that much money at issue in that case. And relatively, I mean, a lot for me, but so, at the time, I didn't appreciate it as much as I think the partner I was working with did, Hal Barza. But yeah, at a certain point, I was like, okay, this is a big deal.
All right. So, and that is Exhibit A or Exhibit 1 in all the trials.
Yes.
3M trials that are going, the Flange. How do you spell it? Just so if people are listening and they want to actually look into this.
Flange, Flange. Yeah.
All right. So you're involved in antitrust litigation, and then that somehow or another evolves into Moldex blowing the whistle and filing the qui tam case under seal. So it's not, the public can't get it. If you're looking on court dockets, you would never even know that this is going on. The case goes on. No one knows about this. How long was the case going on? 3 years?
I think at least 2 years.
Then the case settles, and then at that point, it becomes breaking news.
Yes.
And then everybody's like, so that's sort of like the FDA recall notice. Holy hell, this is a defective product. And 3M acknowledged it. I mean, the Flange Report is them essentially saying our product is that we're selling to the Army is defective.
Well, yeah. But I will say, for that qui tam settlement, 3M, of course, they denied all liability. They didn't, they said they did nothing wrong. So it's not like they came out and acknowledged that something was wrong with this plug, and they still don't.
Yeah. So how do they all right, so they're involved in the whistleblower claim and their case, and they're trying to defend themselves against, they got this smoking gun. And now that's also, in the 3M case, have they taken the same position in both the whistleblower and the 3M in terms of how do they deal with this Exhibit 1? Do they just ignore it altogether? Or do they say the people that wrote it didn't know what they were like? What's their position on this smoking gun?
Well, I mean, they're in a pretty tough position. I think one of the main things they say is, this was only one test. These were isolated tests. These were limited tests. There's been other testing that's been done on this plug where, the testers didn't reach the same conclusion. The military did some testing on this plug. It wasn't the same kind of testing as 3M did. But 3M says, well, if in these trials, if there was really a problem with this plug, other people would have caught it. The military would have caught it. So therefore, and they didn't. So therefore, there's no problem with the plug. That's like one of their main arguments.
Gotcha. Just out of curiosity, do you know what the Army is using now for earplug? Do they have an earplug that they use, a combat earplug?
They use a variety of earplugs. They use one from Moldex. They use another one from a company called Surefire that's been around a long time. They even use subsequent versions of the Combat Arms earplug, but they're single-ended versions.
Yeah.
And they're much different. Yeah.
Okay. All right. So now we got the largest mass tort case, which is evolved from this antitrust, frivolous lawsuit that, we're, trying to basically, become the dominant player in the earplug space. So they were using litigation to, essentially become a monopoly. And what does that have to do with baseball? Like where's the similarity? Because I just met you last week.
Yeah, that's true.
In Vegas, and you're like, yo, baseball, antitrust, figure it out, Greg. So I'm like, all right, and so here we are.
Well, let me first ask you, you're in Miami, right?
Yeah.
Are you a Marlins fan or what?
It's hard. Yes, I am. It is. They were up 4-1 last night. They got down to 4-3. And I just couldn't even watch it anymore. And then they I turned it back on. They won. I was so happy. Yes.
Okay.
Yes.
Well, I'm a Nationals fan, but let's put aside that rivalry. I guess we're division rivals. So
yeah.
And I don't think either of us are very good this year. So yeah, I mean, baseball and antitrust have been in the news lately. Baseball is the only major league sport in the US that has a exemption from the antitrust laws, Sherman and Clayton antitrust laws. And so, that it was a kind of judicially made rule back in, I believe, like 1920 or in the 1920s, where the US Supreme Court came out and said that basically it's okay for major league teams to kind of work together to run this league. And so there's the antitrust laws do not apply when it comes to baseball. Now, there have been other cases since then where other sports involving other sports leagues like NBA, NFL, and the court has said, no. This doesn't, this exemption doesn't apply to those leagues. This is only for baseball. So, I mean, it's been in the news lately because there's been a recent lawsuit involving some minor league teams that are suing the MLB. And I believe some baseball teams too. Basically raising this argument again that they're being harmed by the MLB's actions against some of these minor league clubs. I guess some of them were dissolved in the past year or two, and so some of them have decided to bring suit against the MLB, and they hope that these cases this will kind of be like a case that can reach the Supreme Court again, and maybe they can get that prior decision overturned.
Well, baseball's got its issues. I grew up on baseball. That was my sport when I was a little boy, and I love baseball dearly, and I worry about it. I never thought I would actually worry about a big sport, but I kind of wonder if the Supreme Court says, they don't get this exemption from the antitrust laws, if maybe that would be better for baseball. I don't know.
I can't say either way.
Yeah. All right. No, I don't want to put you on the spot either, but that's just my feeling, baseball needs something. So I don't know, speeding up the game or whatever. But listen, Matt, you did a miracle. You connected the largest mass tort in the history of to our national pastime. And I got to give you a lot of credit. So thank you for coming on to the show.
Yeah, thanks for having me.
And that'll do it for this episode. Everybody have a happy Passover, happy Easter, and be safe. It's a crazy world out there, but hopefully we can all enjoy ourselves this weekend with our family and loved ones. All right, so everybody, you know what to do. Subscribe, rate, review. If you have questions, maybe you want me to bring Matt back on to discuss any other things related to, because Matt, you know, you're going to trial, what, next week again? The 3 of
Yeah,
them?
starts on Monday. Yep.
All right, so if anybody's got questions, listen, there's a lot of people out there, soldiers, maybe you didn't jump in the litigation, it's not too late. And maybe you're like, wow, I do have hearing loss and my ears are ringing, you know, if you have, but you could have both or whatever. It's not too late. You can call Matt. I'm going to drop a link in the show notes. So this show is going to be on YouTube. So if you want to see the earplug that Matt was referencing, you can watch my YouTube channel, or if you're driving and you want to do the audio, you won't be able to see him. He's a good looking guy. So you should do both. You should listen while you're driving and then go back to the YouTube and see the actual piece. But that'll do it. Everybody stay safe, and we will resume another show soon. Okay. Bye, Matt.
Thanks, Greg. Bye.